It's the law with attorney Larry Forman. Folks, I am in shock and horror for all the best reasons. We have just moments ago received information that the jury has questions in the Karen Reed trial. They have three questions specifically, which we'll get to in just a few seconds. And let me tell you, the lawyers right now are conferring, and they are determining as to whether or not, well, not whether or not, but what kind of answers are going to be given to those questions. My hair is not cooperating. I'm just going to let it go. Essentially, the jury, I think, is on the precipice of a decision. They are ready to render a verdict. The verdict is going to happen today. I am convinced. I am everything but convinced at this point. Again, I'm not trying to hype you guys up. I'm not trying, you know me. I only speak the truth. I only say the things that I believe in. I'm going to tell you things that I am 100% wholeheartedly have an opinion on from a legal perspective, as a practicing trial attorney, as someone who does these cases for a living, and someone who has at least, if not at this point, I think more than 50 jury trials of his own under his own belt, under my own belt. So, with that being said, I have predicted this, folks. I have predicted that there is no way that even this jury number 2 in trial number 2 compared to trial number 1, are going to convict on charge 1 and charge 3. And the questions are evident. We have 3 questions, which, like I said, we'll get to in just a second. And those 3 questions are a telltale sign of where the jurors' minds are at. Notice none of them have anything to do with murder. None of them have anything to do with manslaughter. They're all focused. Two out of the 3 questions have the focus on OWI, operating under the influence, DUI, driving under the influence, whatever what you want to call it. So now that we have a crowd here, let me spill the beans on what like I said, this is, I do not want to take the credit. Again, this is just experience speaking, that I suspected that there was the fact that the defense added the DUI charge in the mix is brilliant. I said it before, I will say it again. It is absolutely brilliant, because they have taken away the government's biggest, ace up their sleeve, or whatever you want to call it, to go for that hung jury, to go for trial number 2. And they're like, look, just convict her on the DUI, call it a day, forget about it, and end this once and for all. No trial number 3, concluded in June of 2025. So you never have to look at it again. That was the most brilliant move the defense has done in this case, by adding under charge number 2, the lesser included, charge number 2, number 5, OUI, operating a motor vehicle under the influence. So, what are the questions? Then we have 3 questions. Question number 1, what is the time frame for the OUI charge? Is it 12:45 or is it 5 a.m.? Why are they asking that? In my humble opinion, I believe, my personal opinion, is that I think the jury wants to determine whether or not to convict her of that charge. I have a feeling, a very strong feeling, in their minds, they're already going to acquit on 1 and 3. And this bleeds me into question 3. We'll come back to question 2 in just a second. Does convicting Karen on the OUI convict on the overall charge of manslaughter? They do not want to convict her of manslaughter. This is amazing. This is incredible, because they don't know. They're asking a question. If we convict her on the OUI, does that convict her of manslaughter? Because if it does, we don't want to. We'll acquit her on that as well. We just want to make sure that we're not making a mistake that we're later going to regret, and it is not aligned with our wishes, the jury's wishes, our wishes. As the jury deciding this case, we don't want to screw things up. We want to do things right. So if we convict her on the OUI, does that convict her of manslaughter? Because if yes, then we're going to acquit. But if no, then we're going to convict. Do you understand? That's exactly what they're thinking right now, and that is basically question 1 and question 3. They're intertwined. They're very related. They're like cousins, if you want to call them that, because one is going to influence the other, and the other is going to influence the first. Now, what is the time frame? So my suspicion is they are doubting as to like when was she actually under the influence, because if they're going to say, look, 12:45 she was under the, because theoretically she could have, we know that she came home to One Meadows, John's home. They've heard the evidence. She came home, she connected to the Wi-Fi at 12:42 or 12:36, whatever it was, a.m., 12:38 I think. She connected to John's Wi-Fi, which means she came home and she was texting, voicemail, texting, voicemail, whatever, calling him, and then finally she goes to sleep. She wakes up, she drives over. That's when they did the BAC. Now, are they going to go and extrapolate and assume? Because theoretically, she could have come home, sobered up, woke up, drank some more. So if they're going to argue, the court, the defense, the prosecution, everyone is going to argue like, hey, the consumption of alcohol was at 12:45 and convict her on the 12:45 a.m. DUI, they're going to acquit. Because I think there is insufficient evidence for them to convict her of a DUI at 12:45 a.m. That's question 1. Did the DUI occur for 12:45 or 5 a.m.? Because at 5 a.m. they have a BAC, right? At 5, 6, 7, whatever, they have a BAC, and that BAC is going to be used against her. Unfortunately, look, everything else is out the window. Forget about it. The jury's already made up their mind. There is no more evidence coming in. Your opinions don't matter. My opinions don't matter. The only opinion that matters is the opinion of the jury right now, and the jury is convinced. One of them, the only reason that they're asking is because one of them they're going to convict and the other one they're going to acquit. That is literally the only question. It is now a split decision. They cannot decide, because half of them are like, well, if it's 12:45, I think we should acquit. If it's 5 a.m., I think we should convict, but we don't know which one it is, so we need some guidance. We need some help. Please help us, right? So I think if the court is going to say 12:45, they're going to acquit. If the court is going to say 5 a.m., they're going to convict. What's going to happen though, and let me tell you, this is what courts do. This is what Auntie Bev is going to do in about 7 to 10 minutes here. Is she is going to give them a completely different instruction. Look, you have been provided all the evidence in this case. It is your determination as to what to do with that evidence. Blah, 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 blah. She's not going to answer the question. She's not going to give them a straight answer. She's not going to provide them with the information that they're looking for. She's going to give them the bare bones minimum. This is standard stuff. This is what courts do. This is what happens. This is normal. Deal with it. Sorry, not sorry. This is just facts. But and the jury's going to come back, and now there's a chance that they're going to acquit across the board, folks. There is a chance that we may get a triple not guilty. If Auntie Bev does not give them what they want, and that is a 12:45 a.m. DUI, or excuse me, a 5 a.m. DUI, which is what they're looking for to convict on, I think it's going to be a straight acquittal. At least on charge 2 and charge 1, charge 3, I'm convinced that they're already not guilty. So you're not guilty, not guilty, not guilty. Okay, so that's number 1. That's question number 1. I'm gonna jump to question 3, and then we'll come back to question 2, because like I said, questions 1 and 3 are related. Now, and I think Bev read them out of order. She admitted it. Anyway, number 3, does convicting her on the OUI convict on the overall charge of manslaughter? That is the most important question being asked here today. Maybe. Well, we'll come back to question 2. You'll be the judge. Is number 2 more important than 3? Is 3 more important than 2? I don't know. I think number 3 is extremely important, because convicting her on OUI, does that convict her of the manslaughter charge, the overarching manslaughter charge? That question is absolutely crucial, because that question is going to allow them to decide, well, look, what if we convict her on just the OUI alone? Is she going to be a convicted manslaughterer or murderer or whatever? If no, then sure, let's convict her on the OUI, call it a day, everybody go home. We think she did it, whatever. Who cares? Okay, convict her on the OUI. I said it before, I'll say it again. You want to convict her on the OUI? Convict her on the OUI. Who gives a shit? Who cares? Whatever. That's called splitting the baby. Juries do it all the time. They just don't. They're like, look, the government is charging her. I trust police. Vomit. I trust the government. Vomit. I have to police would never charge an innocent woman, would they? Vomit. And that's what the jury's doing. Like, we can't just let her walk away. Like, obviously she did something. The government did a horrible job. Maybe they have evidence, maybe they don't. Split the baby, give her some, DUI and call it a day. That's what the jury's thinking about. And that is why it's disgusting. I agree with you, Chad, right? So does convicting her of the OUI convict her of the overall charge of manslaughter? That is a question that is leading the jury down the path of, look, we want to convict her if and only if of the OUI, if and only if that does not convict her of manslaughter. Because if that convicts her of manslaughter, no. Acquit across the board. We do not, this is no man, there is no manslaughter here. We are not agreeing to manslaughter. Go to hell. Bev, go to hell. Judge, go to hell. Prosecutor, go to hell. The system, we are not convicting her. That's question number 3. That is what question number 3 means, okay? Now, let's go down to question, number 2. Now, this one is interesting. This one is interesting because clearly the interviews that happened after, right? Because they're like, what does this mean, right? Because these interviews did not happen in trial number 1, obviously, because they were still happening. She was still doing shows. She was still doing interviews. She was still doing showing up on these platforms. And the question becomes, the jury is like, look, she did all of these interviews like after the fact. She did not testify, so we did not hear from her. You instructed us, woman, Bev, that we are not supposed to hold the fact that Karen Reed did not testify against her. But we heard these videos that you played in court. So what do we do with that? Can we take that as evidence? Can we not take that as evidence? And the question is, question number 2, in the way that Judge Auntie Bev read them, are video clips of Karen Reed's interviews evidence, and how can we consider them? That question is going to be simply answered, I suspect. You have been given all the evidence in this case, and this is how, and you are to determine what to do with it. There is no specific instruction that can be given to a jury to give more weight to evidence or less weight to evidence. You can't do that, because then you're betraying the justice system, you're betraying the jurors, you're betraying Karen, you're betraying the defense, you're even betraying the prosecution by basically saying, look, all the other evidence is not as important, but this evidence is important. Like, you can't do that. Everything is thrown into the pot. Brennan decided to introduce her interviews. That was his decision. He is the prosecutor. And so now he's got to deal with it. So what's going to happen? Are video clips of Karen's interviews evidence, and how can we consider them? You have been given all the evidence in this case, and you are to consider the evidence and give it the weight that you determine is the proper weight to give, because you are the jury, you are the arbiters of the truth, you are the arbiters of the decision, you are the decision makers, and you're going to determine what's going to happen, how it's going to happen, and what is going to happen with it. That's it. That's going to be answered instruction number 2. Question number 2. That's going to be the instruction by Bev. And the answer, I don't think I kind of skipped this one. What is going to be the answer to question number 3? Does convicting her of the OUI convict on the overall charge of manslaughter? This is a tricky one. I've never in my life seen a question like that from a jury, because this case is so unique and so publicized. But I think that convicting her on OUI does not convict of the overall manslaughter charge is the only viable answer that should be given from the bench. This is the only answer that Auntie Bev should be giving the jury, because at the end of the day, look, if you convict her on OUI, of course you don't convict her of the underlying manslaughter charge. And so if that's the question, then the answer is unequivocal. This one must be given as a straight answer, in my humble opinion. If I am the judge, or if I'm the defense attorney who would be instructing the judge, I would absolutely say that convicting her on an OUI does not convict her of the overall charge. That is the correct answer. That is the straight answer. That is the proper answer. And that is the answer that should be given by Auntie Bev to the jury. So that's what I have for you folks. Those are the answers to the 3 questions if I were the judge. And I think this is what's going to happen in the next few minutes. I've been recording this video live for about 15 minutes now. Auntie Bev gave the lawyers about 15-20 minutes to come up with an answer to these. And folks, I appreciate you. Thank you for coming to watch this, and I will see you all in the next video. Bye, everybody. And by the way, before I forget, and hopefully within the next, the last thing, I have right now, what time is it? 11:26 over there? 11:26. We're going to have a verdict within the next 2 hours. 2 hours. I said this. I said Tuesday afternoon, we're going to have a verdict. I didn't say it out loud. I kind of kept it on a DL. I didn't want to, but I was like, yeah, we're not going to have a verdict. 0% chance we're going to have a verdict Friday. There's a chance we're going to have a verdict Monday, but extremely unlikely. I didn't believe in it personally. I was like, we're probably going to have a verdict today or tomorrow. We're going to have a verdict today, folks. We are going to have a verdict today. We're going to have a verdict within the next 2 hours. Once these questions are answered, 98% of the jury's job is already completed. They're missing 2%, and they're going to need a little bit of time to kind of sift through the questions. They're going to have their answers, and we're going to get either a triple not guilty, not guilty, not guilty today, or we're going to get a not guilty, guilty on the OUI, not guilty on the charge 3, leaving the scene. So, folks, I will see you on the other side. Bye, everybody.